Hello and welcome to the 2020 election petition, the judgments. I am Mama Viosu Awaji. In less than 2 hours, the Supreme Court shall deliver its judgment in the presidential election petition filed by the NDC's 2020 presidential candidate, John Dramani Mahama. At stake in this petition is Nana Akufo-Addo's first-round victory in the elections. Mr. Mahama wants the Apex Court to invalidate the declaration of Nana Akufo-Addo as the president-elect by the EC and order runoff elections for various reasons contained in his petition. Chief among those reasons is the contention that the results declared by the EC on December 9, 2020, which purportedly confirmed Nana Akufo-Addo as president, violated Article 63(3) of the Constitution because at the time of the said declaration, neither him nor Nana Akufo-Addo had obtained more than 50% of the total number of valid votes cast. He also alleges that the EC was unfair, untruthful, and unreasonable in collating the results of the presidential election because he has evidence of vote pardon and clerical or arithmetical errors in the collation of the result. On December 30th, 2020, Mr. Mahama, of course, filed that petition, and hearing began on January 26, 2021. The court, in its pre-trial direction, sets the issues for determination as follows: whether or not the petition discloses any reasonable cause of action, whether or not, based on the EC's data, no candidate obtained more than 50% of the valid votes cast as required by Article 63(3) of the 1992 Constitution. The third issue, whether or not Mr. Akufo-Addo still met the Article 63(3) threshold by the exclusion or inclusion of the Testimonies South constituency presidential election results. The fourth issue, whether or not the declaration by the EC on the 9th of December was in violation of Article 63(3) of the Constitution. And the last issue is whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. The court also decided that its decision on the preliminary objections raised by Mr. Akufo-Addo won't be incorporated in its post-trial judgments. Well, let's cross over now to the Supreme Court. My colleague, our court correspondent, Joseph Akable, is right there for us. Joseph, good morning to you. This seemed to be the very last time that you'll be reporting on this particular petition from the Supreme Court. So first of all, tell us how this experience has been for you.
Well, as to whether it will be the last, I guess it depends on a decision by the petitioner to exercise its right of filing a review, because the rules allow for a review to be filed, and so that will be dependent on that. But so far, it has been quite an exciting process coming over here and bringing our viewers the very latest by way of the coverage and the happenings at the Supreme Court. It's been an interesting learning curve, and it's been an issue that we've all followed keenly because of what is at stake. I mean, 13.4, 13.1, depending on which narrative you believe, Ghanaians went out to vote on December 7. An outcome was announced and a decision has been taken to challenge that outcome through the legitimate process allowed by law for such a challenge to be mounted. And so it's been exciting, it's been interesting, at times very controversial, especially when decisions of the court has left some parties very unhappy. And so it comes to the very climax, I mean the highest point where we get a response from the judges on what this particular case means and what happens going forward. And so that is how it has been so far, Mavi.
Being at the courts this morning, of course everybody is ready for this judgment, but what's the feel around where you are?
When I came in quite early. There wasn't a lot of security presence. It was similar to what has been the trend over the last a few weeks of covering the process. And so you have about 8 policemen at the entrance of the Supreme Court. Once you are coming in, they are the ones who check the vehicles and make sure you have the necessary accreditation before you're able to come onto the premises. Then there are a number of the policemen stationed at different parts. Just a moment ago, when I was joining the feed for this particular interaction, 6 vehicles moved into the Supreme Court premises. These are military pickups that each had about 5 soldiers on board who were wielding guns, who came into the court premises. And so that is by way of the additional security measure that has come up over here this morning. I spotted so far Johnson Asiadinkete of the NDC. He came in, he's still at the car park. He's actually yet to even get out of the car and come over. I also saw the Director of Elections for the MPP, Evans Nemako, also present here. So those are the 2 people I've seen so far. It appears a lot of the people are still making their way to the Supreme Court as we speak. But in terms of the atmosphere here, we have pressmen who are here in their numbers to get the information and put it across for our viewers and listeners. You also have some few individuals from the security agencies who have also come in to witness. And like I pointed out, the military has joined today to come over. Earlier we had seen military presence, but they mostly came with the EC chairperson Jane Mensah. But this time around we have military men who have come on their own, even without the EC chairperson coming in yet. And so that's by way of the additional security measure that is in place now. And so it's more of a lot of those who are here, the other individuals who are also going about the activity, because there are other courts that are sitting here. There's the Court of Appeal that sits here. There's also the Supreme Court that sits on other matters that are also sitting in separate aspects. But obviously the attention is on the main courtroom itself, where the election petition is going to be heard. And so that is by way of the atmosphere here. Is that of eagerness on the part of security personnel who are present to make sure that everything remains peaceful. You have journalists who are eager to listen and hear what transpires, and you also have some few individuals who have on their own come to monitor the exercise.
Joseph, I'll come back to you for you to talk us through the major events during this trial. Let me welcome Mr. Bobby Benson, who is a lawyer. He's joined us via Zoom. Good morning to you, sir. Thanks for your time.
Good morning, and thanks for having me.
Okay, great. Good to have you. What are your expectations for today?
It's been a long road. Finally, we are there. The rules require that from the date of filing of the petition to the date of judgment should be 42 days. But I think we've gone a little over 42 days. If it was filed on the 30th of December, I think so. So it's been a long road, but we are here. You've seen interlocutory applications, reviews upon reviews, and what have you, a lot of Bible quotations when it matters most, a lot of words, sometimes tensions being very high, but we are there. We are there. We are very sure that today they are going to deliver a judgment. And like they said at the last sitting, if they needed any clarification from any of the lawyers, the parties to the case, any oral submission in further of any point of law or fact that they needed clarity on, they would have asked them to do so. And once we did not get any such signal, we are very sure that everything is set for them to deliver their judgment today.
Okay.
So I'm expecting a very reasoned judgment. Possibly almost all the judges will deliver a written opinion, and so that everything will be very set.
You say that because in his reflections on the Supreme Court, retired Supreme Court Judge Justice Databa applauded the fact that each of the 9 justices back in the 2013 decision delivered a full-length judgment. And he said that was assuring. It was an assurance to the nation that each judge had fully considered the issues that had gripped the attention of the nation and come out with an independent judgment on them. So you are also expecting that all 7 would have their full judgment.
That all 7 would deliver a judgment. Possibly each of them would want to read today. If the judges are of the opinion that it will not matter because of time, then each of them may read a summary of his or her opinion, and then the full opinion or judgment would be made available to the public, the lawyers involved subsequently. But I expect that each of the judges will read a full reasoned opinion. Okay,
I was just going to say, does it matter if it's a unanimous decision? Does it matter that they individually also write their judgments?
Yes, usually, even if it's a unanimous decision, you would see that there will be a lead judgment, by the person whose opinion the rest of them would say, okay, this is the main opinion. But on some specific points of law or fact, even though the conclusions may be the same, you'd realize that each judge or one or two judges may use a different route to arrive at that same conclusion. And so even though you would say it will start with sentences like, I have read the reasoned opinion of my brother or my sister, Justice ABCD, and I agree with her, except that I see the need for me to add one or 2 points of my own for the purposes of development of the law. Until you realize that the facts will be the same, the law will be the same, but in the application, there may be 1 or 2 tweaks depending on where the judge will look at it from. But the conclusion will be the same. And so it's possible, and it's normally the case in matters as sensitive as an presidential election petition.
Bobby Banson, please continue to stay with me. Let me cross over to the Supreme Court. Joseph Akable, our court correspondent. Joseph, talk us through the major events during this trial. I know that you wrote a piece on myjoyonline.com outlining some of the rulings, but what's been some of the major events in this trial?
And so there are 2 ways to look at it. We can first look at it by way of the 11 things that the court has had to deal with. But a more simple way to look at it is that it has all centered around one issue. It has to do with the fact that, one, they needed some information from the Electoral Commission, the petitioners, by way of documents that they wanted to inspect. These are the pink sheets that were used to declare the results, starting from the constituency level through to the National Election Coalition Center. And so they wanted to have access to that. The petitioners wanted to have access to that. The court took the view that those are documents that are already in their custody, and so it did not grant that request. Then there was a request to serve interrogatories. These are some 12 questions that they wanted the EC chairperson to answer. That was also put in. The court turned that down. It went for a review as well. An enhanced panel, 9-member panel, upheld the original panel's earlier decision in that regard as well. Then came the bit related to admission of facts, 18 facts. There was no response to it. And if you read the closing address of Mr. Mohammed's lawyers, they make the point that once those facts were not admitted, were not responded to, i.e. by way of denial, it means that they've been accepted. And so they made references to that as well. Then came the decision by the respondents, specifically the Electoral Commission, was what the petitioners took issue to, deciding that they are not going to call their witness into the witness box to be cross-examined. And so that was an issue that the court was invited to compel the first respondent to elect or direct a witness to come in to testify. And so that also was a ruling against the petitioner. Eventually, it went for a review. The court again arrived at the same conclusion as the original panel. There was another request about the fact that they wanted to be allowed to reopen the case for a subpoena to be issued against the EC chairperson. That also failed by the panel not allowing that. Then came the review as well, the same conclusion. Other matters that have transpired has to do with portions of various witness statements being set aside. We saw it in the case of Mr. Siedu Nketia. We saw it in the case of Roger Metununu as well. Then there's a bit about the request that was even allowed for Roger Metununu, whose witness statement was not initially filed, to also come in to be allowed to testify, a ruling in favor of the petitioners. The petitioners again were allowed at the initial stages to correct some mistakes in the document that didn't go to the substance of the petition. And so you can see it as a lot of decisions that have taken place, but essentially it has bordered on one point, i.e. the petitioner's quest to get information from the Electoral Commission, and that is what the various routes that they have used did not prove successful by way of getting a favorable decision from the court so far. And so that has been how it has been. Those have been my highlights, if you ask me to put a finger on, but it all bordered on the quest to get that information from the Electoral Commission chairperson.
Okay, let me cross over to Bobby Banson. Now that we're talking about highlights of this trial, what would be your major, what would you want to focus on if I were to ask you, and I'm asking you now?
I think for me the most important interlocutory application in the matter was the application for the discoveries, which intrinsically is linked to the application for interrogatories. You would see that the NDCs, or the petitioner, not the NDC, Mr. John Mohammed's case was hinged on the fact that the results that were declared were not a true reflection of the results or what was contained, garnered from the grounds, each polling station, each constituency, and what was sent to the regional level and subsequently to the Electoral Commission headquarters, the coalition center for the presidential election. And because the name of the game is evidence, to borrow the phrase that was used in the last petition, in the by Dr. Afarijan, in the absence of those documents, then you'd realize that the NDC began to struggle, the petitioner began to struggle in terms of presenting his case. And so there were a series of applications all trying to get to that same point. And for me, that is the most crucial part of this whole petition, the fact that they were denied the opportunity to have to have a look or to present from the EC side those documents, the pink sheet, and every other document that formed the basis of the coalition. Because if you go to court to say that one person did not get 50 plus 1, the only evidence, 50% plus 1, the only evidence that you can make that allegation on or contention on will be the raw pink sheets from the police stations. And they didn't attach it to their petition themselves. And they were perhaps expecting the Electoral Commission to do so, and that didn't happen. And so they brought an application for discovery, it was denied. They brought an application for interrogatories, it was denied. And then they were hoping that the Electoral Commissioner, the chairperson, would enter the box. Then they may have an opportunity to cross-examine and then perhaps use another legal way to try and get those documents in evidence. So once that was denied, then you realize that their strategy or there's a problem with the whole approach, and they now had to change their approach as they went along. So for me, that was a very, very important stage of the whole petition, the entire process.
I want to also ask you about the legal tactics behind this petition. And if you may, all the parties, what's been the tactics from where you sit?
Well, not to try and get into the heads of my very senior colleagues. I'm perhaps not fit to wear their shoes at this stage yet. But if you look at the petition, the petition itself was looked to me as if it was filed with the expectation that the respondent, particularly the Electoral Commission, would make available certain documents or at least would testify. And the Electoral Commission and the second respondent, Nana Danko Akufo-Addo, the president, they seem to have led the petitioner on as if indeed they were going to testify. And that would have given them the opportunity, the petitioner the opportunity to do the cross-examination. And so it's like going to play a football match with, let's say, Barcelona, and then you know for sure that Lionel Messi is going to play. And so as a coach, you have your tactics around Lionel Messi. And then on the day time comes and then Messi does not play, then all of a sudden you'd have to re-strategize. And if you don't take care, it's too late for you. You'd have to put your team forward and face the game. And it seems to me that was what happened, that you would see that at every point in time, there was no suggestion from the respondents that they were not going to testify. And they waited for the petitioner to close their case so that legally they will not have an opportunity to come back unless in very exceptional circumstances to adduce any further evidence. And that, I think, that may have been the strategy that was adopted by the respondents, because you would see that they raised the preliminary objection of the petition not disclosing any reasonable cause of action, for which reason it should be struck out. And they raised that after the petition was served on them. And so they knew from day one that as soon as the petitioner closes their case, they were not going to call witnesses, because in law, with civil practice, you have an opportunity to submit what in criminal law would be a submission of no case. If at the end of the case of the plaintiff or the petitioner, your case is that they've not adduced sufficient evidence or they've not established the prima facie case for you to be called to even adduce evidence in rebuttal. And so there's no burden on you to prove. Remember, when you go to court, the burden of proof is first on the person who alleges. And so in this instance, it will be the petitioner. And so if the petitioner alleged evidence prima facie, as we call it, that will shift the burden of proof on the respondents. Then the respondents will be obliged by law or by the Evidence Act to now also adduce evidence to display, to displace the contention that have been, or the grounds that have been made by the petitioner. And so once the respondent filed in their response that they have a preliminary objection to the whole proceedings, and it is that the petitioner's petition does not disclose any reasonable cause of action, then he knew that at the back of their mind they intended ending this case as soon as the petitioner closes their case. And because the rules that govern election petitions now are not the same as the normal rules of civil procedure before the Supreme Court or even the High Court, you know that, for example, the ambit for amendments were very limited. And so you will not be allowed to amend your petition to introduce evidence which was not originally part, or to change the whole course of your petition. So once you file it, it's only on minor typographical errors which the petitioners were allowed to amend when they filed their first petition that you can amend. And so once the petitioner filed their case, I'm sure the respondent looked at it and said, okay, it is not what we thought they were coming with, or it is not as strong as we thought. So we are going to make sure that this does not cross a certain ambit. And I believe that was the strategy that they went into the matter with. And they seem to have played along it very, very well.
But let's be clear, that statement of you have not adduced enough evidence is not coming from the courts, but it's coming from the respondents. Yes.
It's the respondent. It's not the court that said that they've not adduced any sufficient evidence. That would have been prejudicial.
Sure.
If indeed the court is of the opinion that the petitioner has not adduced sufficient evidence, you will hear it today.
Okay. All right. Let's go back to Joseph Akableb. Joseph, we've had 3 witnesses from the petitioner coming forward to testify. And, you know, I guess the very last witness, there was a whole talk about it before he appeared. But let's go back to the beginning. Talk us through the 3 persons that we've seen testifying in favor of the petitioner.
And so the first was Johnson Asiedu Nketia. He is the NDC's General Secretary, and his testimony focused mainly on the declaration that was done by the EC chairperson. He did the analysis and make the point that the EC chairperson mentioned 13.4 million as the total valid votes cast. And so if you use the 13.4 million as the denominator and you put President Akufo-Addo's votes of 6.7 million up and multiply by 100, he's going to get less than 50% of the votes cast. And he makes the case that for all the other candidates too, if you do the same, you're going to realize that they've all had less than 50% plus 1 of the votes cast. Then he again makes the point that in the same regard, when you put together the percentages that were announced by the EC chairperson, you are going to get 100.3%, which he says is a mathematical impossibility. And so that was the crux of his case. His testimony centered on that December 9 declaration. Again, you realize from the petition that the petitioner takes the view that after December 9, the EC has not done any other declaration, because they say that the person who has the power to do a declaration is the returning officer for the presidential election, who is the EC chairperson. And she did 1 declaration in the opinion of the petitioner on December 9. Reference is made to the statement that was issued by the commission, which they say was unsigned, and so it cannot be said to be a declaration coming from the returning officer. And so whether errors were committed or errors were corrected, as far as the petitioner is concerned, per the declaration on the December 9, no one won the December 7 post. And so that was the testimony of Mr. Asiedu Nketia. And you recall he was cross-examined, and the cross-examination mainly by Mr. Kotoampao centered on the mathematics. And so he took Mr. Asiedu Nketia through the figures that the EC chairperson announced on the December 7 day, what she allocated to each of the candidates, and requiring Mr. Asiedu Nketia to add those figures together and saying that when you add those figures, what do you get as the total valid votes cast? And you heard Mr. Asiedu Nketia say that you get 13.1 million, but that operates on the assumption that the figures that I'm tabulating are actually correct. As far as I'm concerned, he says, in his opinion, those shows it's internally inconsistent in that what is being he was asked to add doesn't tally with what the EC chairperson announced, and they are going by what she declared, which, as it stands in his opinion, is legally the declaration that has been done. And so that was by way of Mr. Esienu Nketiah's testimony and the cross-examination. Then came Dr. Mayeko Pesa-White, who was one of Mr. Mohammed's representatives at the EC's National Coalition Center, which we popularly call the Strong Room. And his testimony made the point that, look, in the course of the coalition exercise that we're undertaking there, we had concerns about some of the results. We sought audience with the AC chairperson. We pointed it out to her. We actually wrote a petition and sent it to. She asked us, instructed us in his own words, to go over and confer with our presidential candidate. And while away, she proceeded to declare the results in our absence. And so we believe that she acted in a biased manner and executed this in a manner that was geared at just ensuring that we are away from the National Coalition Center. He insisted that, look, they were not leaving. They left the equipment there. Then the questions were asked of him during cross-examination that, did you at any point interact with the EC chairperson anyway? Then he said no, but the information about us being instructed to leave came in from Roger Metununu, who went and spoke to the EC chairperson. And so at that point, at the end of the proceedings, everyone was asking the question that, look, so why did Mr. Roger Metununu, who was said to have had this interaction, come in to testify? Then eventually a request was made that Mr. Roger Metununu, who for some health reasons couldn't put in a witness statement, should now be permitted to put in a statement and come in to testify. And that statement came in and was the final testimony that came up. And he did indicate that in the course of the interaction with the EC chairperson, he alleges that they were told to go over and confer with their presidential candidate, and while away, they got the news that the EC had declared the results. They saw it on the TV that the declaration was under when the results had been declared, and he confirmed that he had indeed signed approving some of the coalition results, even though he told the Supreme Court that he had concerns about some of the specific results, even though he had appended the signature confirming them. And so that was by way of his testimony. And the cross-examination that took place with regards to Roger Metununu centered on questions about why he had a mobile phone and he didn't place a call to the presidential candidate and required both of them to leave the place, and also why they didn't have additional 2 people because they were permitted to have 4 persons at the place, yet they had only 2. And he was explaining that it was because of what had transpired and the magnitude of the information they had to convey. That is why they opted to go about it that way. Another important question that came up, which I left out of in terms of Mr. Esienu Nketiah's testimony, was what came from the panel about what, in the opinion of the petitioner, is the votes that the petitioner himself obtained and what the second respondent also obtained. And you heard Mr. Esienu Nketiah tell Justice Yaopewo that they've not come to court with those particular results as well. And we've heard the petitioners, even at the end of all this testimony and cross-examination, make the point that their case is premised on the declaration that was done by Electoral Commission on December 9. Aside from the other issues related to the vote pattern, which they said they've brought a sample of, which amounts in the region of a little over 4,000 votes, which they also talked about as well. And so that is by way of how the case traveled. And obviously we touched briefly on a bit about the decision by the respondents not to call their witness into the box. There was a statement from the AC chairperson Jane Mensah and another also from Peter McMahon, but we didn't see those statements they coming into the box to have those statements adapted as evidence and being cross-examined.
And Joseph, I want us to also talk about the 3 leading lawyers that we've seen, making their submissions during this trial. For the petitioner, we've had Chacha Chikata. We've seen very little of Mr. Tony Litha, even though he does a lot of administrative work in terms of documentation. We've heard him speak a few times, but the lead lawyer for the petitioner has been Chacha Chikata, Justin Amenuvo for the Electoral Commission, and Mr. Akutu Ampao for Mr. Kufuor. Tell us about these 3 gentlemen and what's been your experience watching them make their case in courts.
I mean, it's been exciting to hear from them. And Mr. Chikata, I mean, obviously, he's quite a popular lawyer in Ghana here. Someone who we know for a fact taught almost all the judges at the Supreme Court hearing this particular petition. Some of them have actually admitted in the course of this particular proceedings that he was their lecturer. And so he's quite an experienced figure here. And he's been practicing from the 70s all through to currently. And he was part of the 2012-2013 petition as well when he represented the NDC. You recall the NDC made a request and was allowed to participate in that particular proceedings, and he led the NDC's legal team then. Mr. Tony Lita at that point was President Mahame's lawyer, lead counsel in that particular affair as well. You have Mr. Kotampa and Frank Davis, who both were also part of the president's legal team, then making it as part of this particular legal team. Then you have Kwesi Ofi joined by Yao Pong making part of the president's legal team. Then the other, Justin Amenuvo, who previously we know that the commission, in terms of the 2012-13 petition, had Kwashi Aidan representing it. Subsequently, when Charlotte Osei became the EC boss, the commission was represented by Thaddeus Sore, but currently Justin Amenuvo of Amenuvo and Associates leads the commission side. I must say that from Mr. Chikata's side, we've seen he taking his time in terms of the way he speaks and addressing the court, mostly at length and going through to put across his case, and in a fearless manner, in a manner that we don't often see in terms of how lawyers address the courts. And I'm sure that is a point that anyone who is familiar with the court process will agree with, even by way of how he interacts with the justice of the Supreme Court. And so a lot of experience brought to bear, and assertiveness, and a lot of wits, and in some instances even citing the scripture to make his point as well. And so that has been by way of Mr. Chikata. We've seen Mr. Amenuvo, who has been quite direct in terms of his submissions in the court. He is mostly brief. He goes to the highlights of its points and wraps up quite quickly on that. Then Mr. Kotampa, who relatively speaks longer if you compare to Mr. Amenuvo as well, aided by his colleagues to put across his case as well. He speaks a bit slow as well, but puts across his points and making reference to relevant case law, among other things, just like the other lawyers have also done in the course of this particular case. And so it has been quite exciting, and it's been a display of legal wit and brilliance from the lawyers on all sides who have handled this particular case, and they are all hoping to get favorable decisions today. But we know that it cannot be a decision that will be favorable to everyone. Or at best, it cannot meet their needs entirely.
Absolutely. Let me ask Bobby Banson what he makes of these three lawyers that we've talked about. These are your learned friends, even though they are your seniors.
One has a different style of advocacy, and you would see it come into play with a manner and style of presentation by each of them. Senior Chachi Chikata, we expected nothing less, very upfront, and he's very confident in his approach, knows what he's about, and so he comes across like that. At the end of the day, he's protecting the interest of his client, and he chooses to do it that way. Lawyer Kotampa, we've known him from practice to be a very calm person who speaks slowly but very surely, and he makes his legal argument very forcefully, but not, of course, in the same aggressive manner, if I may put it like that, by Mr. Chikata. I've seen Mr. Chikata on his feet in other matters where he's been less aggressive than he's been in this election petition. It just lets you know that the stakes are different, and the stakes in this matter are very high. You would see Mr. Amenuvo, Lawyer Amenuvo, also coming across with a different style, very direct, very, straightforward, and almost like, okay, we are here for this, A, B, C, D, I'm done, I'm walking. But you would have different lawyers having different styles of cross-examination. Some would want to attack your credibility before they come to the substance of the case. Some would want to go straight to the substance of the case before they come and attack your credibility. And some would want to do both simultaneously, so that the questions that he's asking is soliciting answers that would attack your credibility and at the same time destroy the substance of your case and adduce further evidence in support of his or her case. And so you see that there's different styles, and it's a good lesson for law students who are learning advocacy.
Okay, let's go back to the beginning of this matter. And when I say the beginning, of course, this is the second exercise of the election jurisdiction under the 1992 Constitution. Proceedings in Ghanaian courts are not ordinarily allowed to be televised, although the proceedings are public. Unlike 2012, the decision to broadcast proceedings live was quite straightforward in this case. I want us to look at what is similar to 2012, 2013, what's been significantly different. And I would like to start with Joseph Akable. I know that you didn't report from the courts, but there's a lot that you're learning in this process. Any comparisons?
I mean, I think the first obvious difference that I see is the panel, the size. And so this time around, you have 7 judges hearing the case. And so that is a significant difference that I realized. Also, by way of the duration, how long this whole process has lasted. Of course, we've gone beyond 42 days, but unlike the 2012-2013 situation where you had, 8 months of court hearing before a judgment was rendered, that is also very different. Then again comes to the nature of the cases itself. And the counsel on the other side, Mr. Banson made the point about the pink sheets. In the 2012-2013 instance, you had the petitioner coming to court with pink sheets attached, even though they even made a request nonetheless to inspect the other pink sheets in the custody of the Electoral Commission, and the court in that instance declined it, and in this instance the court also came to that same conclusion. And so that is by way of similarity and differences in the nature of the case that has taken place. Again, you recall in the 2012-2013 situation, the respondents elected to give evidence. They called witnesses to come in, and the witnesses testified, not by way of the witness statement like we see today. They were led by their counsel to give their testimony, and afterwards they were cross-examined subsequently. In this particular instance, we've seen respondents opt not to lead any evidence at all and call any witnesses to even be cross-examined in that particular instance as well. And so that is also by way of another difference. The obvious similarity again we see is that the actors, which is quite interesting. In the 2012-2013 situation, Nana Danko Akufo-Addo was the petitioner, and back then in those rules it permitted, he had more than one petitioner. So he had Mr. Akufo-Addo joined by J. Kotanko Bechebilamte and Dr. Mahmoud Baumia filed the case against the Electoral Commission and Mr. Mahama. In this particular instance, you have Mr. Mahama becoming the petitioner in the new rules and what was stated in the manual and the way it was couched. Mr. Mahama is the petitioner in this instance, then has as the respondents the EC and Mr. Akufo-Addo in this particular instance. So that is by way of how some of the actors have crossed and moved to the other side, and how it's similar in terms of the other case and how it's different as well.
Bobby Banson, there are 7 justices of the Supreme Court hearing this matter. Again, very different from what we witnessed in the 2012 petition, where there were 9 justices and the CJ was not on the panel. This time, we've got the CJ in the chair as well. What's been significantly different apart from these 2 that I highlight?
The empanelment of judges is an administrative decision that is solely within the ambit of the Chief Justice. Even when the Chief Justice is the subject matter of the suit, the Chief Justice's authority to empanel judges cannot be whittled away. So it's solely within their discretion. The Chief Justice may decide to empanel 9 or 5 or 7. And so there's nothing legally untoward about that. Now, you would also notice that in the 2012, the Chief Justice, then Justice Georgina Wood, it was public knowledge that she opted out because she was in the same church and had some level of relationship, let me put it that way, with the president then, who was also a party to the matter. And so she said, listen, for conscience sake, for good sake, let me just step out for the rest to sit on the matter. And so that is why she refused to sit. If it's a question or an issue as important as determining who will be the president of Ghana, unless there are exceptional circumstances like the former Chief Justice found herself in, I see no reason why the Chief Justice, who is the head of the judiciary, should not partake in that exercise or should not be a panel member. Save that you notice that I think most of the judges that sat in the 2012 petition are no longer at the bench. And so you'd see that very few, I think it's about 2 or so, that were then there that are still part of this panel. And so you'd see that there's the first timers, let me put it that way, with this exercise. And yet they've mastered the process. They've been masters of their court. They've not allowed anything to distract them. What also interests me with this was the fact that they sort of commented on the kind of press conferences that were going on, even after immediately after some sittings or some rulings. shows you that they were very up to speed. They were also following media coverage and were listening to it. So if you go out there and you say anything, immediately the next thing they will tell you, we are not very comfortable with the way you said this because that is not what it is. And so it shows that they were following not only what was happening in the courtroom, but also what was outside the courtroom, because they wanted to be sure that at every point in time, the general populace got to know the truth and not what the politicians or the parties involved would come and tell them. And so they were very quick to correct any misinformation that is given out there. And so you notice that even for the lawyers who spoke for both parties after certain rulings were delivered, when they said things that were not a true reflection of what happened, immediately they come to court the next day. The Supreme Court judges would say, listen, you went to say so and so and so. That is not exactly how it happened. You see that there were also moments where the Supreme Court judges passed certain comments that would lighten the atmosphere when they saw that tensions were very high. For example, they were making fun about the wake of Mr. Kotuampao was just release tension, as we call it. And when it came to even the contempt issue, you see that the approach to this one had only Dr. Dominic Ayeni being hauled before the Supreme Court for contempt. In the previous one, I think there were
about 5?
More than one person, yes, that was all. And you'd see that the approach to that one was quite harsh than this one. But with this one, you see they made their point that, listen, we are not going to allow you to scandalize the courts, irrespective of who you are. We would make sure that we protect the integrity of the court, not our personal integrity, but the integrity of the office that we occupy. And despite the fact that they were very clear with their intention to protect the integrity of the court at every point in time, they still gave the contemnors the opportunity to openly show repentance, and then they tampered justice with mercy. So those are some of the pointers for me in the approach by the bench.
Great. Let me welcome Mr. Martin Pebble to this conversation. Good morning to you, sir. Thank you for your time. Hello, Martin Pebble. Can you hear me?
A second. Yes.
Okay.
I can hear you.
All right. I heard you 1 second.
Yeah.
Just hang in there for me. Let me go back to the court, Joseph Akable. What has changed in terms of the people that have arrived at the court for this judgment?
In fact, by way of the names and the individuals that we've seen come over to the courtroom, by way of the lawyers, the spokespersons, they are all in the courtroom. In between this interaction, I've seen Kojo Ponkroma, the Minister Designate for Information, going. I've seen the legal teams. I've seen Mr. Kotuampao, Frank Davis, all coming over to the courtroom. I've seen some members of the NDC, like the General Secretary Johnson Asiedu Nketia, also coming in and going over to the court as well. I'm here to support the Electoral Commission chairperson and her deputies who have regularly come into the court at all times as well. I'm here to see them today, but those are the individuals that have come in so far. Just what is happening on the compound now is that there are brief moments where you have a bit of the security men going around, the policemen going around the premises just to ensure that everything is safe. I've gone upstairs briefly before we started the interaction to check what the Supreme Court looks like. I mean, the same arrangement like we've had in the past, well spaced out to ensure that the COVID-19 protocols are observed. There are people who check you before you even go into the courtroom itself by way of taking your temperature. There are, say, Veronica bucket hand washing available. Then once you even go in, you are scanned as well before you are even allowed into the courtroom itself. And so, I mean, the conclusion will be that all is set for the Justice of the Supreme Court to take their seat, led by the Chief Justice, to deliver this decision on the 2020 election petition. Okay,
Joseph, this is your very first election petition coverage. So I have to ask you, before I let you go, seat number 87, what are your expectations?
So seat number 87, like you said, is my seat upstairs. And I expect a decision that will be quite detailed. We may not see everything read out as we saw in the 2012-2013 situation, but at least a summary that gives us a sense at first glance of what the conclusions are and what the basis of those conclusions are as well. And obviously we would expect to also hear from the various parties on what they make of this decision and the way forward, whether they intend to exercise their right of review depending on how it goes as well. And so that is by way of my expectations, and I'm rushing up to seat number 87, Mama V.
I know. Are you allowed to take your pen and paper to make notes?
Yes, it's our mobile phones that are not allowed in, but we are allowed to go in with our pens and our diaries.
Okay, all right. Joseph Akable, court correspondent, go and take your seat number 87. Hopefully, this proceeding will start at exactly 9:30. We'll hear a lot more from Joseph Akable, our court correspondent. Trust him to break down the issues for you right here. Mr. Martin Pebble, well, welcome again to this conversation. Bobby Banson has been with us, helping us appreciate how far we have come in this matter. But I've got to ask you, we've got 7 justices on this panel. I think in the very beginning, when we spoke, you were expecting 9, but we've had 7. But we've also had reviews, and we've seen new judges, justices of the Supreme Court join the panel on 3 occasions. We've had 3 different justices also join. Give us a summary of what you make of the proceedings so far.
Yeah, okay, so good morning, Bobby, good morning, everybody. Yeah, so the way I see it is this, that we have moved our democracy and the judicial system a few notches higher, okay, in several respects because of these proceedings. Number one, you see how we've shortened the period it takes to conduct this trial. Although we targeted 42 in the law, but through some exceptions, we've ended up with about 57, or is it 58 or so? Yes, that's not bad at all. So the number one thing is that we've shown that, okay, we can do it in a far shorter period of time. And that's kudos to the judges and the lawyers all together, okay? Then, number 2, we've also shown that at least to the extent that the rules have been simplified, or it's been made in such a way that we should finish the petition within a very short time, through the review applications of Mr. Chikata and other things, we call it pushing the frontiers of the law. He's pushed through his applications for review, and the justices too have accommodated him admirably. So in terms of pushing the frontiers of the law, we've done very well. So that's something that we should have finished simply in 42 days. Through the wizardry of Mr. Chikata, it's gone to about 57, 58 days. Yes, so that's the second point we should note. Then the third thing is that I see in this petition that it didn't evoke as much tension as what happened in 2012, 2013. And that's a very positive development. So you see in 2012, running into 2013, there was a lot of tension in the country, you know, such that even businesses were affected. So many businesses were like, oh, we are waiting for the results of the verdict of the petition before we invest or before we take further investment decisions and all that. So it was kind of crashing the economy in a way. But this time round, it's as if nothing is happening in the Supreme Court. Business has been going on as usual. That is good. And then also, hello?
Mr. Pebble, we can hear you. Please continue.
Yes. Then, another very salient thing I'd like to note is that you see in the 2012 petition, which got repeated here in terms of fairness of the process. You see, at that time, there was an application by the MPP in the 2012 petition that the EC should produce the original pink sheets. You know, the MPP went with thousands of the pink sheets. Sometime initially said 11,000, later the accounting brought it to about 10,000. So let's call it between 8,000 and 11,000 pink sheets. At a point, some were not clear, and the MPP wanted the EC to produce the originals so that they can make photocopies. The Supreme Court refused. Okay, in that application, it was unanimous, 9-0. Okay, now you see it repeat even before we come to the 2020 petition. But in the final decision, you see that Justice Doche had regrets as to why the court refused to produce those, order the EC to produce those pink sheets, the originals. The same way for Justice Akuto Bamfo, she also had regrets. You say, so for me, that was quite a highlight. I like the honesty in it. That, okay, initially, Justice Doche and Akuto Bamfo were part of the 9-0 decision that said the EC should not produce the originals. But later they themselves, after KPMG counted and all those controversies, they saw the wisdom in, these two justices saw the wisdom in ordering that the originals be brought. Bring it to 2020, and then here again, the request, you see, this is 7-0 first, right? So the commonality in it is that, okay, so it appears, they tell you that history repeats itself, right? Yeah, so for me, I'm waiting to see in the final decision whether some of the justices will have a change of mind that, oh, when Mr. Mama applied for the EC to produce the originals, they should have allowed that, you see? Yes. So that is a very good thing that I'm looking forward to in the final judgment.
Okay. Well, gentlemen, I want us to discuss what happened yesterday by way of the press briefing. The bench, the bar, the Ghana Journalists Association came together. I want us to, first of all, listen to Supreme Court Judge Yoni Kolindi.
God willing, tomorrow, the court will speak. When judges speak, that's the end of our role. It's not our place to get into studios, into debates, into commentaries, and to explain. That responsibility falls to you as the anchors who take information out. So if you inform, you can also misinform. It's the responsibility of those of you as the media who educate. If you educate, you can miseducate. And that is why, you know, if country will do well, if we will go forward, if our cohesion will be maintained, a lot depends on you and the professional circumspection, introspection and reflection and care that you bring to bear on your role as the anchor that takes the information out. I couldn't say it better than George did. You will have to take this phase of the responsibility very seriously. It's as important as the role you have performed in transmitting the proceedings worldwide, because at the end of the day, the Ghanaian people own the process. And it's important that they understand what went on, and that when the judges speak, irrespective of our preferences, our likes and dislikes, by the rules of engagement, the referee blows the whistle and the lots fall where they fall. And so let's be constructive, let's be proactive. And His Lordship has said, I should tell you that as trustees of the People's Power of Justice, we are willing and happy to be criticized. Criticize us as violently as you can, but for Christ's sake, don't insult us.
On behalf of all the lawyers, to render an unqualified apology, if there be one needed, to all the authorities involved in the discipline of lawyers. Indeed, after the elections and throughout the petition, tempers were very high. know that the ownership structure of the Ghanaian media prevents some of you from being as professional as you ought to be, or what you want to be. So there's nothing we can do given the pluralistic nature of the media. All sides of issues are peddled. But for the sake of heaven, for the sake of national unity and cohesion and stability, our appeal to the media community in general, please inject the highest degree of circumspection in tomorrow's judgment, so that at the end of it all, Ghana will continue to be at peace with itself and at peace with the rest of the world. On this note, once again, I thank you for what you have done, and may the God of heaven bless you all.
It's the election petition, the judgment. We're live here on JoyNews, on Facebook, on YouTube, on myjoyonline.com, also live on Joy Prime. The judgment will be delivered. The court will sit at 9:30 a.m. My guests via Zoom, Bobby Banson and Martin Pebble. Earlier, we engaged our court correspondent, Joseph Akable. We've just heard the Chief Justice speaking through Justice Yoni Kolindi, saying there that we're willing and happy to be criticized as violently as possible, as you can, but don't insult us. We heard the Ghana Bar Association president also speak, and the president of the Ghana Journalist Association. Let me start with you, Bobby Banson. First, the Judicial Service spoke to the media through its lawyers. In fact, they wrote a very long letter. And then yesterday, there was a combination of the bench, the bar, and the GJA. What do you think is happening here?
I obviously will start from the letter that was written. To be fair, I think the essence of the letter was to remind all of us the obligations that comes with exercising the right to criticize the judiciary. And so the letter, in essence, was to tell the media in particular that, listen, the Judicial Service is not very comfortable with the manner in which some of the comments are published by these media houses, and that is a reminder of your obligations to uphold the integrity of the court and not to publish anything that will be seen to plunge the administration of justice into disrepute. For me, that is the essence of the letter that was issued by the lawyers for the Judicial Service. However, it's received a lot of backlash and opposition and resistance because of the manner in which it was presented. And I will not say that some of the grounds for the resistance are unfounded. There are legal grounds for, debatable grounds or arguable grounds for resisting or holding the letter, the messenger, let me put it that way. The messenger was not the person that should have carried the letter, because it was a private legal practitioner and not the Judicial Service as an entity, which is headed administratively by the Judicial Secretary, who in practices or by the law has the same position as a Court of Appeal judge, I think so. And so it received a lot of backlash from that angle. Also, the manner in which some of the wordings were put out also received a lot of backlash. And so I believe that it sort of was presented as if there was an impasse between the judiciary and the Ghanaian media. And I don't think that was the intention of the letter or of the Judicial Service. And so to make sure that the dust settles on this matter, everybody knows that the judiciary is not at loggerheads with the media or even the Ghana Bar Association. Then there was a need for a joint press conference between all these three institutions to make sure that any doubt as to the relationship between the media and then the bench or the judiciary, if you may, and the Ghana Bar Association is that conception or that misconception rather is taken away. And if you listen to Justice Yoni Kolendi, who was in private practice for a long time, who had some occasions not to be happy with decisions of the bench, really understood how to approach this. And if you listen to him, he was very clear that you can criticize us as violently as you want. And I don't think that the judiciary has ever said that don't criticize us. But in as much as you do, don't scandalize the court. Don't scandalize us. Because scandalizing us means that you are not attacking us as our persons, but you are attacking the very office that we occupy. And so if you go on, for instance, and say that the judges delivered their decision because they were influenced by A, B, C, D, it means that you are attacking the judiciary. And I keep on saying that the judiciary is the only arm of government that we are sure is not influenced by partisan politics. And so you know that the legislature is made up, people are there because of their political color. The executive, people are there because of their political color. But the judiciary, if they are appointed by even the sitting president, they are nominated rather by the sitting president, they are approved by parliament. So it means that their appointment is confirmed by the representatives of the Ghanaians. And so you cannot say that they are there based on their political color or their decisions are influenced by their political color. If you take, for example, this election petition, some of the decisions, some of the applications by the petitioner have been granted and some have been dismissed. And so the judges, I believe, wanted to let everybody know that, but through Justice Yoni Kolendi, that we are not above criticism. We expect criticism, but in as much as you do, make sure that you stay within the boundaries allowed by law. It is your right to criticize, but that right comes with certain responsibilities. And for me, it was a master stroke that that press conference was jointly done with the GJA and then the Ghana Bar Association, because these are the three main stakeholders apart from the parties before the court in this whole exercise. And so for all of them to come and tell Ghanaians that we agree that you can criticize, but you must criticize responsibly, it goes to show that our democracy is expanding, is growing, is maturing, and we all are understanding it as the days go by.
How have we performed as media in this particular election petition? We haven't done badly at all, have we?
Well, you can't, I'm not sure you can say that for all the media houses.
Oh, yes. Yeah, but sorry, Bobby Banson, I was directing this one at Martin, actually.
Okay.
So Martin first, and then you can have a bite.
Yeah, Mama V, you guys overall have done excellent. Yes, to be very honest with you, you've done excellent. Look, I tell you, you know, when you watch the way the public is following, and even number one, let's start with the way you try to educate. You make sure that you are cross-checking your facts and the legal steps before you go out on air, and then the reactions we get from the public. Overall, look, I think we can beat our chest and say we've done extremely well. The media have done well. Look, in every society, we are bound to once in a while have some erring members. It's normal. You hear us say in every house there's a Mensa. If you be a Mensa, it's not only in Ghana. All over the world there is. But I'm looking at how you set out, you know, before the court sitting, sometimes you would call other panelists you intend to host the next day. And then you would even ask the questions ahead. Because trust me, before we come to talk here, we would have to read, you know, the 2012 petition judgment. Look at it. It's over 500 pages. Yeah, over 500. So sometimes it's good we read over so that we can bring perspectives and all that. So you give us, you know, notice ahead. Okay, sometimes it's not sufficient. But what I'm looking at is the fact that you prepare. It's not as if you just get up and then you put the microphone on and start talking. So the preparation is like a lawyer preparing to go to court, you see, and asking for explanations here and there, or sometimes you even giving us pointers. Yes, I'm a lawyer, but sometimes you, Mama, you say, oh, counsel, do you remember this? Do you remember that? So there's a whole learning process. And the way you put it out in the public, I tell you without any equivocation, you guys have done so well across the board. For the few times that the judges have had to complain about the media, as I've said, yes, it's bound to happen. That the society, we have different temperaments. So those few ones cannot give all of you a bad name, not at all. And then so we all know that under Article 162 of the Constitution, it's part of your mandate as the media that you shall hold governments accountable, ensure responsibility, and all that. So I see this, the coverage, the extensive coverage you are giving as part of fulfilling your constitutional mandate.
What can we criticize? Where can't we go on this decision? And it's not just media, because a lot of people are also following, and they might want to go on Facebook or go to whichever platform and make commentary. But just to say that a while ago, the petitioner, John Dramani Mahama, walked into the court. So he is in court today. And we're also bringing you live pictures from the courtroom where the justices will take their seats and deliver judgment. That's John Dramani Mahama just walking in. He's the petitioner. We know that he hasn't been in court for some time now, but he is back today for the judgment. And that's chairman of the party, the NDC, meeting him. He's taking his seat now. So things look to be in shape, really, in the courtroom for this judgment. If we're going by the time that's advertised, in about 8 minutes, we have to see the justices take their seats and deliver their judgment. But let me come to you, Bobby Banson. I'll start with you. What can we criticize violently, and what can we not?
Violently? I believe that it's a matter of knowing the difference or drawing the line between attacking the personality of the judge and then attacking the reasons of the judge. Judges deliver justice, or the courts deliver justice in accordance with law, in accordance with defined practice, and in accordance with statute. Case law, statute, well-defined practice. Those are the three ambits for the delivery of justice. And so if you criticize the reasons or what the judge is saying that this is our decision, your criticism must be based on case law, it must be based on statute, or it must be based on well-defined practice. And so if you say that the judges held A or concluded on A, and then you think that there's an authority, either by case law or by statute, or by well-defined practice that held otherwise, you are free to say that, no, this is what it is. Previously, this is how you have held it. And so I think that you should have followed that line of reasoning. You are free to do that. But the moment you start saying that, well, they held it to be A because they were influenced by other things outside these three ambits I have mentioned, that they were influenced outside by things outside case law, statute, or well-defined practice, then you have crossed the line. Then you are scandalizing the courts and then attacking their integrity. And nobody would allow that.
How do we know, and we're not just, again, speaking to media, but there are ordinary persons out there who might want to criticize the decision of the court today, which is allowed, but how do they know where to end it?
Like I said, these are the ambit of
okay.
Senior Martin.
Yes, I wanted Martin Pebble to also speak on this. Mr. Pebble, can you hear me, please?
So, yes, I can hear you.
Okay.
So simply, it's insults. And when we say insults, it's not just limited to stupid, foolish, no. But don't say things that patently mean that the justices are not reasoning, but that they are just doing the bidding of a certain party or president who appointed them. You say, so even if you don't say somebody is stupid, but you say, oh, Justice X has written why it's written because he was appointed by President Akufo-Addo. That is it. That's contemptuous. Because then the meaning is that, oh, he has no brain anymore. Oh, it's Akufo-Addo's case. Oh, then Akufo-Addo wins. You say, so that is it. So concentrate. If you want to critique, sometimes they say we should use critique, right? You want to critique the decision, concentrate on what it is that's on the paper. So let's take a typical example. You know, you've been engaging us. Let's take the most contentious issue that came up during the hearing thus far. The application to have Jean Mensah take the stand so that she can be cross-examined, etc. The justices refused. And you see how across the legal fraternity, it divided us because a lot of us saw that no, for all the reasons. I mean, looking at the affidavit she swore, oh, these questions can be asked in cross-examination. Even some of the justices themselves even intimated that, yes, these questions can be asked in cross-examination. The filing of the witness statement, yes, I will admit, it doesn't ipso facto mean the person will come into the box. But putting it all together, you could see that there was a good case for bringing in Mrs. Jean Mensah to testify. So we could complain. So we've shown that, look, I belong to the sociological school of thought, where the purposive approach comes from that school. So you look at all the circumstances and you look at the mischief, okay, that you want to avoid. So bring in Jean Mensah, it also accords with common sense. Sometimes the law is also common sense, etc. You see, the justices haven't complained. They also use a different school of thought, positivism, etc. So that is it. So you see, we brought in jurisprudence. So though these justices are, some of them taught us in law school, they even continually teach us in court and the rest. But on a matter that was so controversial, we showed that, look, it's not everything they write that we agree with. You see, so we expressed our opinion clearly that, look, if we're using jurisprudence, we could have a difference of thought of jurisprudence, because the schools are, if we're using the sociological school and even to some extent the natural law school of thought, would have called in Jean Mensah to testify. That's a clear example. You say, so what we are saying, so I'm demonstrating that use reason, breed law, ask lawyers to give you reasons to critique, but don't go saying stupid, he's an NDC man, he's an NPP man, he was appointed by President Akufo-Addo, he lives with President Akufo, he comes from this town, those kind of things. No, that's where a person will be entering the realm of contempt of court.
Okay. All right, great. Just very finally, do you expect a review of a decision today? Bobby Bunsen? Or maybe Martin first? Who's going for this?
Well, I'll leave it to Senior Martin to take a shot.
Okay, so, Mama V, yeah, because I'm taking a second attempt at answering this question, I hope to do better. I will ask the same question on News 9 tonight. So, number one, it all depends on the outcome, right? Okay, so that the outcome that will determine, okay? So to that extent, it means that the rest of what I'm going to say is speculative. So, you would expect that in the event that Mr. Mahama wins, by all means, you would expect the president to apply for a review. You say, yes, because he's on the throne now, okay? He is in office. So if the Supreme Court were to rule in favor of this and give judgment in favor of Mr. Mahama, you would expect the president to apply for a review, because it's not easy to leave the Jubilee House, right? If they were to give judgment in favor of President Akufo-Addo and the EC, then it means ordinarily Mr. Mahama would be applying for a review. But I think that using precedent, that in 2012, when President Akufo-Addo lost, then as candidate Akufo-Addo, he said he disagrees with the Supreme Court, but he would not apply for a review. I expect Mr. Mahama to reciprocate the gesture, because these things they must come to an end. Which game must come to an end. They've done well. Mr. Chatuchikata has been brilliant. He's pushed the judges. They've also accommodated. It was brilliant. You know, there were times people thought he was rude and all that. And I said, no, look, we as outsiders, so to speak, we don't understand the relationship between Mr. Chikata and the judges. So they are doing their own thing. The most important thing is that are they applying the law? If so, let's go. You say, So the point is that he's done well. Mr. Kutampa, Mr. Menuvo, all the rest, Yaopo and the rest, they've all done well. It's okay. In the event that Mr. Mahama loses, please, let's not have a review. It's okay.
All right. Okay, Mr. Pebble, I think we're losing you there. So let me just quickly cross over and get your say on this. Bobby Bunsen, on the review question.
That is what I...
Okay, can you hear me?
Yes, I can hear you.
Well, I do not expect a review if the petitioner loses the case. Review because unless the judgment has some fundamental and patent error of law that is so obvious, then of course you would expect that in the interest of justice they will bring that back to the attention of the court. But in the absence of that, if it's divergence of opinion on the facts, or the evidence-led and the position of the law, then I do not expect the petitioner to file a review. I agree with Mr. Martin Pebu, Senior Martin Pebu, that if indeed the respondent, the sitting president loses, then it may be interesting. He definitely may want to have a second bite at the cherry because it will not be easy to... Everything that he has done since December 7th then would have to be reversed. January 7th when he was sworn in, let me put it that way, would have to be reversed, and that would be interesting. But in all, I do not expect a review from the petitioner if the petition is refused.
Okay. Let me just remind our followers that we're live, of course, here on JoyNews. Live on Joy Prime is our 2020 election petition, the judgment. This is our coverage. As you can see, they're all set in court. All the parties, including the petitioner himself, who was in recent days been represented by Johnson Asierun Ketia at some point, or the party chairman of the NDC, but today he is in court for the judgment. We've seen quite a number of lawyers. The Electoral Commission chairperson is also in court today. We saw how she walked in court hand in hand with the husband, who's obviously coming in to give her support. We've seen other persons from the second respondent as well, the lawyers and also representative of the precedent, Peter McMenu, also in court today. So all is set. We're waiting for the 7 justices of the Supreme Court to deliver this judgment. You can make comments, keep it clean. And as you've heard from our lawyers this morning, make sure it is good reasoning. You can send it and use the hashtag election petition. That's what we're using live on Facebook, on YouTube, Joy Prime, Joy News, and myjoyonline.com. My name is Mama Viewuswabwaji. Our lawyers this morning helping us digest the issues, Martin Pebu and Bobby Bunsen. After judgment, we will be joined also, in addition to Martin Pebu and Bobby Bunsen, we'll have Oliver Baker Vomawo, who is a researcher at the Corpus Christi College of the University of Cambridge, also join us so we can understand the judgment that has been delivered. The advertised time, of course, was 9:30. So I guess any moment from now, we will have the 7 justices. And we've just been informed, Martin Pebu and Bobby Bunsen, that the decision will be at 10. So we've got some 30 more minutes, a little less than 30. Martin Pebu, you are right on this. Was it 2 days ago that you said that this will not be at 9:30, but it will be 10? So you were right.
Yes, so it happens. It's all right.
Hello, Martin. Martin, I seem to be having...
It's almost time. It will be here before we do it.
Mr. Pebo, I am having issues with the network, I think, because we seem to be losing you. You are clearer now. You are talking about the time. It's been moved to 10 o'clock now, we understand.
Okay, yes, I'm saying it's fine. It's the 30 minutes. It will be here before we know it. So maybe I'm interested in this. If I can bring it up. Reading through the 2012 petition judgment, one thing that struck me was, before Mr. Mahama went to court, he had asked that the EC should audit its systems, okay, after the announcement of the results. This thing generated a lot of controversy. People were like, oh, he should stop it and go to court. After the EC has announced the results, there's nothing more to do. You should go to court, Then, as I started reading the 2012 petition judgment again, I saw that the MPP, they are exactly the 2012. They asked the EC for an audit. They asked the EC for an audit, exactly like that, So I was like, wow, things never change. I'm even trying to get a copy of the, let me see the letter, yes. Yes, exhibit, this one, audit, yes. Hello?
Yes,
Mama, can you hear me?
I can hear you. I can hear you loud and clear.
Let's read a bit of it. It's good history so that people will see that these politicians, they are the same. Because when we get wiser, that is how we can hold them to account so that they will stop in us. Look, 9 December 2012. So I'm reading at page 334 of the 2012 petition judgment. It is called Special Edition 2013, the Supreme Court of Ghana Law Reports, at page 334. This is in the opinion of Justice Doche, where he reproduced the letter from the NPP. It says, 9th December 2012. This is a letter written by Jake Otanka Obichibilamte. It says, address the returning officer, Presidential Election 2012, Electoral Commission, Accra, DSA, request for an audit of verification machines and recount of the presidential ballot. I write as chairman of MPP to express concerns of our party over the conduct of this year's general election, particularly with regards to the presidential pool. I am doing so because conduct and declaration of results of a credible process is the surest way to promote the peace and stability of our democratic nation. I hereby copy of a statement I've issued, which I set out in detail our concerns. So EC should cause an audit of the verification machines and then order a recollation of the presidential ballot at the constituency level to help establish the credibility and accuracy of this year's presidential election, blah, blah, blah. So you see it. So when Mr. Mahama asked for a similar thing, hey, people were happy, and no, it's not possible, it's not possible, it's not possible, it's not possible. Go to court, go to court, go to court, go to court. But here we are, you see it. Yeah, so for me, that's one thing that caught my attention.
Okay.
I know the public, I think people should buy it and read. It helps.
Sure. Well, thank you for bringing that up. Bobby Manson, do you foresee us going to courts? Yes, we did hear that, Martin Pebo. Bobby Manson, I was just asking, do you see us going for another petition in the future? Is it an easy thing to do?
Well, I think that as long as the presidential candidate feels strongly that he won the election contrary to the declaration by the EC, the right to go to court to challenge it would always be exercised. We have learned it will not it will not necessarily stall government business. You realize the 2012 one took very long. A lot of economic activities were not very vibrant because nobody knew the outcome. But this time it's been done within a maximum of 58 or 57 days. And it shows that we are learning. I believe that the next manual would correct some of the errors that the judges identified in the procedure or the processes with this one, and it will always make it better. So I mean, as lawyers, we would want the frontiers of the law always to be expanded. And then if there's an opportunity that is well-grounded, hey, why not? Any defeated presidential candidate should take a bite at the cherry and see if there will be an opportunity. In an African country, I don't recall, East Africa, I think Malawi or so, where the judges asked for a rerun as a result of an election petition. And so it's possible, it's doable, that one day there may be an outcome, if not today, where the judges would indeed overturn the declaration by the Electoral Commission. So if they are legal, they are factual basis, I mean, every presidential candidate would exercise that right to pursue it in a court of law. And as long as it does not affect the overall peace and stability of the nation, why not? If it's a better option, we should exercise that right.
Pebu, before you joined us, Bobby had talked about his expectation and talked about if we were to get all 7 justices independently given full-length judgment, that will be good for this petition. What's your own expectation? Exactly the same. Considering that this is a very crucial matter of national importance, the public interest, and everything, it's to be expected that each one of them will write an opinion, just like the 2012 petition. That's why it's over 500 pages. So that's what is to be expected. But at today's sitting, I'm expecting that they will not read every opinion because that would take too long. So just like was done in 2012, hopefully they will summarize the conclusions and give the verdict. Then they would announce that the 4 opinions can be obtained from the registry. I think that would be more efficient use of the time, which is a very critical resource. Yes, but to have all the 7 justices give their independent opinion is basic, it's to be expected. Yes. Well, one of the things that I guess we're also looking forward to will be the consequential orders of the court. Any expectations in that area as well? Martin Pebu first. Yeah, so it means that winning, so let's clarify this. Mr. Mahama winning this case in the event that he wins is that he wants a rerun. According to his petition, I mean, the plea of it is that nobody crossed the at least 50% mark. So it means that he wants a rerun. So if he were to win, the consequential order would be that, yes, the EC should go ahead and organize a rerun between the 2 of them. That one, it means the rest of the other candidates do not qualify. It will be a straight race between Mr. Mahama and President Akufo-Addo. So that's the pitch of it if it were to happen. If not, well, then that's it. Bobby Benson?
Yes,
Mr. Pebu, Mr. Pebu, did you land?
Hello?
Okay, Bobby Benson, please go ahead.
I'm done.
Okay.
Yes, I agree with the submission by Senior Pebu. If indeed the petitioner's petition succeeds, then the Supreme Court will then make consequential orders based on the reliefs sought by the petitioner, ordering for a rerun between the 2 leading candidates. However, Senior Pebu, what ignites my mind is whether you think the Supreme Court will make any award of costs to be paid. I mean, whichever the outcome would be, one person will win, one person will lose. So, and in normal practice, whenever you go to court and you lose, you must pay the legal fees and the filing fees of the winning party. So we want to see if the Supreme Court would make an order in respect of cost, so that if the petitioner wins, then the respondent and the two respondents would then be made to pay the legal fees and the filing fees incurred by the petitioner. And if the petitioner loses, the respondents would have to be reimbursed with the legal fees that they spend. That is one interesting area I'm looking at, whether the Supreme Court would make any award as to cost.
Bobby, I'm thinking that in line with the practice in constitutional cases that they usually don't award costs, this one they shouldn't, especially before Dan Ferro expanded the frontiers of the law. They've all done very well, so they should know. Yeah, they shouldn't be.
Any award of. Well, let's see.
No.
Okay, just one bit about you lawyers. We talked about the issue with scandalizing the court, but we know that the court itself had called out certain names and said that they were uncomfortable with their commentary after proceedings. In this particular petition, we've seen that the Judicial Service has created this platform for all parties. We don't see the Electoral Commission take advantage of that, but we've certainly seen the second respondent and the petitioner take advantage and address the media. This is the last day. This is the judgment. Of course, they've already warned lawyers. So how do you see things proceeding? Of course, if you're on the losing side, it won't be exciting for you when you address the press.
Yes, that's to be expected. But I think overall, it won't be that bad. It won't be that bad because, especially as you put it in context, because of the warning from the court, I'm sure all the lawyers are on their guard. So I don't expect many slips that lawyers will say things that would scandalize the court. No.
Bobby Banson?
Well, I expect that after the verdict, it should be the parties and not their lawyers who address the media, like it happened in 2012 when then candidate Nana Addo addressed the media after the results. That is what I expect, because at this stage, a lawyer's duty ends the moment a judgment is delivered. And so after judgment is delivered, the clients no longer retain your services unless there are fresh instructions. And I have a strong feeling, like your reporter noted, or you noted that President Mahama or ex-President Mahama had been absent from court, but he is there today. And then whichever the outcome is, I expect that he would be the one who would address the media, and then the respondents to either an official of the Electoral Commission or an official of or a representative of President Nana Addo Dankwa Akufo-Addo will address the media. Will it not be a beautiful sight if they address the media together, accepting the results and then urging their supporters to stay calm, not to celebrate or not to celebrate or not to demonstrate, and then allow the system to work. Whichever way it goes, this will not be the last election. So if there is a joint media conference by the representatives of all parties immediately after the judgment is read, accepting the outcome and urging to abide by the decision of the Supreme Court, that would be a very beautiful sight for our democracy.
Immediately with a joint press conference accepting and saying, I disagree, but I respect the decision of the court, whichever way, wouldn't that take a bit of time? I mean, when judgment is delivered and you've lost, don't you have to take a bit of time to reflect and see which direction you want to go, Martin Pebu, before you make public commentary?
This one, I'm sure both parties have been psyching up. They know they are, it's a binary outcome. That it's either a win or a loss. I think there's a point in what you've said. Yes, that ordinarily the loser needs time to grieve. But this one, because of the millions of supporters that each has, that is, we're talking about the sitting president, Nana Addo, and then Mr. Mahama, the response has to be immediate. And as for the jubilation, the one who wins naturally is supported.
Well, unfortunately, the connection is getting really bad now. Martin Pebo, it's difficult to hear you. Maybe we can try and re-establish contacts again on that Zoom connection with you. Lawyers Martin Pebo and Bobby Banson with me as we wait for the court's decision. Decision time, I guess, is in some 10 minutes when the court sit to deliver its judgment on this 2020 election petition filed by former President John Dramani Mahama, who himself is in court today. What is at stake? Of course, in this petition is Nana Akufo-Addo's first round victory in the elections. Mr. Mahama wants the court to invalidate the declaration of Nana Akufo-Addo as the president-elect by the EC and order runoff elections for various reasons contained in his petition. And I'll just mention a few of those. It is the contention of the petitioner that the results declared by the Electoral Commission on December 9, 2020, which purportedly confirmed Nana Akufo-Addo as president, violated Article 63(3) of the Constitution, because at the time of the said declaration, neither him nor Nana Akufo-Addo had obtained more than 50% of the total number of valid votes cast. Again, the petitioner, John Mahama, alleges that the EC was unfair, untruthful, and unreasonable in collating the results of the presidential election because he has evidence of vote padding and clerical or arithmetical errors in the collation of the results. And just a bit of background, of course, 30th December, Mr. Mahama filed the petition and hearing began in January. The court, in its pre-trial directions, set the issues for determination as follows: whether or not the petition discloses any reasonable cause of action, whether or not, based on the EC's data, no candidate obtained more than 50% of the valid vote cast as required by Article 63(3) of the 1992 Constitution. Again, whether or not Mr. Akufo-Addo still met Article 63(3) threshold by the exclusion or inclusion of the Techiman South constituency presidential election results, and whether or not the declaration by the EC on the 9th of December 2020 was in violation of Article 63(3) of the Constitution. And finally, whether or not the alleged vote padding and other errors complained of by the petitioner, John Mahama, affected the outcome of the presidential election result of 2020. And the court decided that its decision on the preliminary objections raised by Mr. Akufo-Addo will be incorporated in today's judgment. So, gentlemen, I want to ask, maybe Bobby can take this one. Should we expect all 5 questions raised to be answered?
Yes. Once those are the issues set down for determination by the court is obliged to respond to each of those issues. Now, they may respond to the issues not in the same order as they set them down, or if they think that facts, evidence, and law relate to more than one issue, they may lump up one or more issues and then resolve them together. But definitely there will be a resolution of each of the issues, either distinctly or together.
Martin? Well, I'm afraid I may not have Martin Pebo joining us in about some 7 minutes or so. We should see the justices of the Supreme Court handling this matter take their seats and deliver judgment. Usually, Bobby Banson, of course, this is an election court handling this matter. I was going to ask how long judgment would take.
Well, I do not expect anything less than an hour and a half to 2 hours. And that is even if they will not read all. I mean, these justices, trust me, would want to pen down every single authority in support of their position just for posterity's sake. And that may quite do some reading. I think if you recall, the whole every single decision in the 2012 petition, I mean, came to about 500 pages from all the rulings and everything. And so we expect quite a voluminous reading, judgment. But as expected, they may not read everything. They will give us the summary of each. And I do not expect less than an hour and a half today.
Okay. Well, I will let you take a breather. Of course, we're following this judgment, and we will have another round after judgment is delivered. As we can see now, if you're watching television, well, it looks like things are getting ready. We're almost at that point where we will see the justices walking and take their seats and deliver this judgment on this election petition 2020 filed by the petitioner John Dramani Mahama, who is in court today, a petition that he filed back on the 30th of December 2020. Before today, though, we've had quite a number of decisions delivered by this same court. On January 19, for instance, the court unanimously dismissed an application for interrogatories filed by the petitioner seeking leave of the court to elicit some answers to questions relating to the conduct of the elections from the first respondent, the Electoral Commission. Again, on January 28, the court unanimously dismissed the petitioner's application for a review of the court's January 19 decision on his application for interrogatories. Fast forward to February 3rd, the court unanimously dismissed the petitioner's application to inspect document of the first respondent, that's the Electoral Commission, relating to the December 7, 2020 presidential election results. The court held that the petitioner had failed to demonstrate that he had no copies of the documents in question. Let's go forward again to February 11. The courts again unanimously dismissed argument by counsel for the petitioner seeking leave of the court to compel chairperson of the Electoral Commission, Jane Mensah, to testify after the Electoral Commission had elected not to adduce evidence. February 16, the court unanimously dismissed an application by the petitioner to reopen his case and subpoena the chairperson of the Electoral Commission, Jane Mensah, to testify as an adverse witness. And on February 18, the court again unanimously dismissed an application filed by the petitioner for a review of the court's February 11 decision not to compel the chairperson of the Electoral Commission to testify. And then on February 22nd, the court unanimously affirmed its February 16 decision not to allow the petitioner to reopen his case and compel the chairperson of the Electoral Commission to testify following a review application filed by the petitioner. So a number of decisions that we've seen the court make in this particular election petition. But this is the ultimate, right? Because in all these, it's bordered around the issue of either asking questions or getting document from the Electoral Commission. But this is the decision, or this sitting is what decides the issues proper as set out by the Supreme Court and the justices sitting on this particular matter. Of course, this is shared by the Chief Justice himself, Kwesi Enim-Yeboah. And as we can see, if you're fortunate enough to be watching television, it looks like in the next minute or so, maybe seconds, we'll see all 7 justices walk in and take their seats. You can join us with your comment. Use our hashtag election petition. Send us comment on Twitter, on Facebook as well. When we come back after the judgment is delivered, we'll have our lawyers join us, Bobby Banson, Martin Pebo, and also Oliver Baker-Vomawo. And they will be breaking down. So don't worry, if it's too hard for us to understand, we will help you break all the issues down. And as you can see, all is set now. So we will take you live to the Supreme Court as we join this election 2020, the judgment.
Respectfully, my lords, writ number J1/5/2021. John Dramani Mahama, Electoral Commission of Ghana. Nana Ado Dankwa Akufu Ado. Respectfully, my lords, petitioner present. Jean Mensah, chairperson, representing the first respondent.